Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Kratz and Dina Davis, P81545. Nice to see you.
Good seeing you, sir.
I have closed captions on, but it's not showing.
Objections to garnishment?
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to
Object to any stay of the garnishment. Right?
Yeah, that's the lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
Do you want me to call the hall or something?
Well, Adams, Gross.
No, I know them.
No.
The landlord docket here sometimes gets spicy because I saw a case from last week where the landlord and the tenant, they didn't get along at all. The landlord switched off the Wi-Fi, and when the tenant was away at work, he went down there when she was away to some medical. She has some medical issues, so she has to be away to get treatment. He goes down and unscrews the light bulbs to save energy, and she has this nerve illness of some sort. She shouldn't be on ladders, but every time she comes home from one of these treatments, she had to go on a ladder to screw in the light bulb again. Judge Simpson wasn't happy about that. So sometimes these landlord-tenant hearings gets spicy.
The defendant having failed to appear, the motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir. May Shen versus Fatima Stevens.
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurgy on behalf of Jing Mei Shin, P8321.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Council and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting, because at that time I was made aware that the owner was intending to sell the home. So it would have benefited all parties if we were able to make this transaction occur. It has taken a little bit of time. We've all I can't say we've all, but council and I have corresponded through email, as you've seen. The property manager, who is also a realtor, and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager who was in correspondence with my realtor and lender is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so anyway, long story short, I had not looked for alternate living. I wasn't intending to seek alternate arrangements to move out because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Response.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original is conditional order of dismissal
Correct.
was put into place with contemplation of a sale?
That's correct.
No, Your Honor.
Oh,
That is not.
oh, disagreement.
Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody well, let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was a, after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And, as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that
The
were,
text messages, Your Honor?
yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff side, Your Honor, there is a realtor who's the property manager who had asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. It's called it, and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at. There's someone on the plaintiff's side that is talking to somebody on the defendant's side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, well, between the person that's a realtor on the plaintiff's side and a realtor on the defendant's side.
So the person who's a realtor on the plaintiff side has no agreement to sell the home. There's no.
I get the fact that there may not be some agreement between plaintiff and this person.
Okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They helped,
Vis-a-vis the property.
they helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property.
Okay. Okay. If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what
This other person being whom?
the person's name is Kirk Glassel.
And that's the person that,
Mr. Defense Attorneys, why is this news in this case that seems to have been up before Judge Glanville? No, sorry, up before Judge Simpson. Before? Why is this news to Judge Simpson? Why is this news?
that now you're saying is nothing regarding this property?
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson
Oh,
and I were,
turn off that
Thumbs
phone.
up and, no, go ahead.
yeah, this email that we were both a party to verifies what that discussion was and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor. In the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual in particular. And then
This person who now is being claimed to be nothing.
Yep, exactly. That's.
I do have other.
Well, okay, hold on, folks. This may make sense to you, it doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then, right, but is, okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there certainly is the potential for some confusion regarding that. And I think that's part of my
I do have more recent communication as of yesterday with the same person,
with who?
with that same realtor and yeah, and my realtor and the lender.
And the lender?
That's
So if Your Honor, if I
Go
can
ahead.
clarify, I have an email right here between all parties, just clarifying what has happened in an email. And the email includes her realtor, this email chain includes the an email from
Okay.
her realtor, back and forth. I believe it's relevant.
Okay, but Mr. McCurdy, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on.
Right.
If she hadn't been misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor. And what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. it was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he.
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right, I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That,
Oh, yeah.
The
go ahead.
realtor the realtor who's standing on the plaintiff's side had I don't believe had any communications with the lender for mistake.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone call, or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that would,
Okay. Okay, that's my concern. It may very well be, Mr. McCurdy, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
It looks like it. Looks like it. Yeah, it seems like girlfriend/tenant trying to pull something off here. Oh, well, when I told you when we started looking at this, Judge Simpson's landlord-tenant court, sometimes shit goes down. Sometimes shit goes way down.
Ms. Stevenson has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try to put together an offer for this home. If any of those things are true, I don't know. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable. But I don't believe the writ should be overturned.
Oh, Judge Simpson is not happy. Oh. Oh, he's not happy.
Yeah. Evidentiary hero. I didn't know when I could do it. When did we set the current?
August 11th.
Okay. Afternoon.
This seems to be an accurate interpretation of what's going on here. She pretended to want to buy the home, get a realtor, no communications to owner, but tell the judge you want to buy. That's why you haven't left. Slow roll, scam, so she can stay for free. Yeah, that seems like what's been going on here.
Yeah. So
Okay.
yeah, it's already at 1 p.m.
Got it. I understand. The problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
Right, but I don't,
okay.
I hear you, but if you had from the plaintiff's side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go.
Or it's the other way around.
Or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired. Because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me, doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing.
That's
Right. But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and prudent on this court's part to to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm gonna rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Why?
They're written on their signs.
No, I'm gonna give it to.
I actually think here that Judge Simpson. Now we don't have access to the communications as Judge Simpson has in their filings, but yeah, I think he got it on the face of it. I think he got it switched around, but who knows? Who knows? Hi, Dave. No, we covered the hyperbaric chamber case the first hour. You're late. You're late, Dave. So now, as we are awaiting the next hearing, I'm expecting, we are checking in on Judge Simpson.
Why are you up here?
You don't put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff. Defendant.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
So I'm
Morning, Your Honor.
Good morning, sir.
as I said, I'm expecting another hearing. I think it's the latest I saw. It should begin at 11, which is in 10 minutes. Once it's up and running, we will go over there. But for now, let's check in on the landlord-tenant docket. And I said it in the beginning. These things get spicy sometimes.
Morning, John.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks Occupant.
Pardon?
Doshia Banks Occupant.
Doshia Banks Occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No,
All right. Why
So-
are you there?
What is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case.
What? Claim to be a tenant, then file bankruptcy to stay. Now the bankruptcy is lifted, and here they are again, apparently.
Case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor. which includes it is
I'll be up
further
here.
ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud BMC REO LLC.
Oh,
Additionally, Your Honor, the bankruptcy
Two in a
court
row.
ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
wow.
All right.
So, my interpretation, she's a squatter who then, in order to avoid being thrown out, made a lot of claims. Those were, of course, rejected, and then she filed for bankruptcy. And in bankruptcy, everything against the person gets stayed until the bankruptcy case is ruled upon. And it seems like the court said, go fuck yourself. We're lifting this back to court. That is my interpretation of this. 2 in a row? 2 clusterfucks in a row. I said it. Judge Simpson's landlord-tenant docket gets spicy sometimes.
Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order
Of course she has.
in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that
Seems like we have a professional scammer there.
need that because
Okay.
I'm not
The reason that I mention all of this, Your
Yeah,
Honor,
go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
Oh,
The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
oh, that's an
Ma'am?
interesting way to force her.
Yes, Your Honor?
What do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well,
She's a sovereign citizen. Oh no. Oh, please tell me she's a sovereign citizen. Oh, wow. What did we get ourselves into? What did we get ourselves into? Oh, this is amazing. Poor Judge Simpson. You can see on him. Oh no. I didn't want this today. Ah. Oh, this is amazing.
then
Any
you are
rights?
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Oh, I assume her and Miss Whitlow are the same person. And she's trying to scheme this by using an alias and then having a lease with that party. And now she's trying to insert herself as a named party. No, as Judge Simpson said, if you're not a named party in this case, fuck off. Well, he's using his own words, but yeah.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to
What?
what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction, so I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, It doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay,
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay,
So this might be a default judgment. Oh, ha! Just because she thought I'm going to walk in as a separate person. Yeah, no, not working, not working. Yeah. This is not the first rodeo for Judge Simpson.
if I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You're not a named party. You're not a named party in this.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Oh, this is going to be a separate video.
okay, I'm not really understanding, but
No, because you're a dumbass.
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stated to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay.
Oh, she's not giving up. Oh, lady, go away. Move out. Fuck off. Oh, this is funny. I told you guys, your Simpsons court, landlord-tenant court,
All right, Your Honor, I will
shit happens.
speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right.
Oh, I think
Based
I'm
upon the
going to stay with
representation of
Judge Simpson
counsel,
for
I'm
a
going to
while.
grant their motion
This,
to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate. And I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would
oh,
need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that information.
Oh, Judge Simpson, let's make sure. Let's make sure. $15,000 a month. Oh, yeah. Yes.
Presented to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all.
Not his
I'm
problem.
not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
That is, you need to get the Whittlers in here, which will be very, very hard because you're probably Hitler. So she has to come in as her alias. Look at the smile on Judge Simpson. He knows exactly what he's doing.
Thank you.
Thank you, Your Honor.
Thank you.
Oh, that was amazing.
I know, you didn't write it.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's in recess.
Oh, wow. Oh, that was amazing. Oh, this is so going to be a separate video. Oh, oh, yeah. So she allegedly, as an alias, rents this $1 million property, and shenanigans ensues. He probably doesn't pay rent at all. And they have been trying to get rid of her for quite some time. And in this scheme of hers, allegedly, she then filed for bankruptcy, which means everything goes to stay. They can't continue with the eviction. Then the bankruptcy court said, fuck off. And now it's unstayed. And then she tries to go to court as herself, renting from herself under another name to get this. And she had no standing whatsoever. So this was more or less a default judgment, which Whittler, or whatever the name was, now they can come in and appeal, which will be a problem for this lady, because then she has to come in as her alias. Now, I would not be surprised if we, in a later landlord-tenant hearing, will see her come in as her alias and try to... Oh, that was amazing. Yeah, I'm going... Yeah.